You are listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to LawWithDenise.net. My name is Denise. In this video, we are exploring the following three questions. The first one is, what is a contract? The second is, what elements make up a legally binding contract? And then the third question is, what is the role or purpose of the English courts in contract law? So let's start off with question one. Question one was, what is a contract? Now, most of us would probably say a contract is an agreement between two parties, and we would probably quickly mention agreements between tenant and landlord and agreements between employer and employee. These are both correct. These two examples are both correct. Yet, I would be quick to remind you or to let you know that there are other types of contracts there which exist, which do not necessarily come with official written documents, such as those between employer and employee and tenant and landlord. Because the essential thing for you to remember when you are defining a contract is that a contract is technically a legally binding agreement between parties. It's a legally binding agreement between two parties. It does not have to be written down. Now, I'll give you an example of what could be a legally binding agreement between two parties which is not written down. When, for example, I need to get someone to fix my bathroom or to paint a bit of my flat, I don't know about you, but I don't normally send them a written document, and they don't normally send me a written document stating how they will do it, when they will do it, etc. Normally with work like that, the agreements are made verbally. Also, when I go to get my hair braided, I don't normally write a contract prior to the hairdresser taking out my braids and redoing them. But these are, in fact, contracts. These are, in fact, agreements. Specifically speaking, the first one, which involved the workman maybe painting my flat or fixing my bathroom, this is potentially a legally binding agreement. So potentially it is technically a contract. Now, what do I mean by legally binding? This should be the question popping up in your head now. What does she mean by legally binding? Well, what I mean by legally binding is that it is an agreement that the court will be interested in listening to and remedying if something has gone wrong. So we make agreements all the time. We make agreements with people all the time. We make them with family members. You may say to your brother or your sister, if you clean my room, I will give you £50. And you may feel that after the room is done, even though it's done perfectly, you may feel, you know what? I'm not giving you £50. Now, your brother or sister may well be very disappointed and perhaps angry, but that person, that party to the agreement, may struggle to get a court involved because the courts would not probably recognize that as a legally binding agreement. Now, in order for an agreement to be legally binding, there are specific elements that need to be present in the contract, in the agreement. And this is our second question. What elements are necessary for a legally binding contract? And those elements are offer and acceptance, consideration, and intention to create legal relations. Now, an offer is the proposal made by one party to another. And the agreement is the exact acceptance of what is proposed by the other party. So, for example, if we go back to employer and employee, the employer may well offer 35 hours a week in exchange for £400 pay. That offer is made, you as the employee, you accept it, and then you have an agreement. So far, we have two elements met for a legally binding agreement or contract. Additionally, what needs to be present is what I call consideration, or what the law books call consideration. And this is anything that is exchanged within this agreement. So in the employer and employee situation, there is an exchange of work for money. So something is being given, something is being passed. That's your consideration. Intention to create legal relations simply means that there is some intention, whether explicit or not, that if something goes wrong with the contract, the law can get involved. So you can take this person to court. Now remember, I mentioned the agreement between brother and sister. Oh, if you clean my room, I'll give you £50, right? With that agreement, you would have had offer and you would have had acceptance, because otherwise the brother or sister wouldn't have cleaned the room. There was consideration because there was money promised to be exchanged, and there was work being done or promised to be done in exchange for the money. But this, I said, probably wouldn't be recognized as a legally binding agreement or contract. And this, I said, because it would have probably failed on the grounds that there was no intention to create legal relations. The court would probably be very unconvinced that when a brother and sister went into an agreement which involved an exchange for £50 to clean a bedroom, there was, even though not explicitly said, an implied understanding that if there was any breach of this agreement, they would end up in court. So you probably wouldn't be able to bring such a case forward. So those are the elements we look for in order to argue that an agreement is in fact a legally binding one or a contract. And those are offer, acceptance, consideration, and intention to create legal relations. All those elements need to be present before we can say that an agreement between parties is in fact a legally binding agreement or a contract. And the other question is, why would we want to, or why would we need to convince a court that we have these elements present? Well, that takes us on to our third question. Remember, our third question was, what is the purpose of the courts, or what is the role of the courts in contract law? Now, we may end up in court if, for example, with my scenario, so my scenario involved me asking a workman to come and paint my flat or do my bathroom, right? So let's stick to him coming to paint the whole flat. And let's say I give him a certain amount of money to buy the materials, because usually they say they know the right materials to purchase, so we should pass on the money to them, or sometimes they purchase the material and then you give it back to them. But let's say I give him the money to purchase the materials, and I also pay him a certain amount to get the work started, and he promises that he will get the work done by a particular time. Now let's say that after this agreement, it's not written, it is verbal, but there is offer, there is acceptance, there is consideration, And there is intention to create legal relations, right? It's not explicit, but it's implied. It's a business transaction. So it's implied that, if things go wrong, we both have rights. But so I agree, I give him the money, the work is supposed to get started. Now, upon completion, I realize that the work has not been done completely. So he's decided that he's going to leave out the kitchen despite our initial agreement that he would do the whole property. At this point, he's already received, let's say, 50% of the money for the work. So he's received 50% of the money for the work. He doesn't finish the kitchen, and he leaves just the kitchen undone. He then says he needs a bit more money to buy more materials in order to get the kitchen done. He takes my money and he goes and he then buys extra material to get the kitchen done. But what he does is he paints the kitchen in a different color to what I expected. And he also removes some of my equipment and doesn't put it back. So I have now a washing machine that's not in the right place. For some reason, he also took down some of my cupboards and he left them when he was going. At the end of this, I'm pretty mad, okay? I'm pretty mad because that wasn't part of the agreement. I kind of expect you to leave my kitchen in a good condition, and I expect to be able to wash my clothes after you've left. I don't expect my equipment to be moved. Now, this is the point at which I need the courts. I need the courts, and I need the courts to help me with perhaps getting him to complete the work properly, and perhaps I need some money back, because in fact, when he left the kitchen in that state, I had to get somebody else to finish the work properly. And I also needed to get somebody to reconnect my washing machine and to put back the cupboards that he had removed. So that's cost me extra money. So now I'm in court, and I'm in court because I've lost money as a result of his poor performance. The role of the courts in contract law, even though I'm angry, is not to make me feel better emotionally. The role of contract law is to put me back in the position I would have been in had the contract been performed properly. So therefore, the court is concerned with how much money I have lost as a result of this poor performance, or quite frankly, breach of contract, right, with this workman. So they want to know how much money I spent to perhaps to get the kitchen redone, because if he had done it properly, I wouldn't have lost that money. And so that is the role of contract law, to put you back in the position you would have been in had the contract been performed properly. Now, before the courts even begin to look at the breach and examine the type of breach in order to, and also determine how much money you're going to get back, or whether the workman needs to come in and redo the work, before we get to that part, the court needs to know whether or not this agreement between the parties was in fact a legally binding one. If not, it's none of their business. And it is for that reason why we need to be clear on what these elements of a legally binding agreement or a contract are. So the courts will be interested in putting back parties in the position putting parties in the position they would have been in had a contract not been breached. But the courts are also firstly interested in finding out whether or not a legally binding agreement was reached. And in order for us to determine whether or not a legally binding agreement has been reached, the court looks at whether or not there was a clear offer, acceptance, consideration, and intention to create legal relations. So thank you very much. I hope that was useful, and see you later. Bye.
You've been listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you. You've been listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of